Tinubu's long-anticipated response to the district court in Chicago has finally emerged. It appears that the issue of privacy has shifted its prominence. The argument surrounding the potential violation of Tinubu's privacy if Chicago State University's records were handed over to Atiku seems to have been relinquished. For those unfamiliar with this legal case, a brief recap is in order before delving into the reasons for opposing the release of Tinubu's Chicago State University records. In Nigeria, anyone aspiring to hold elected office, including the presidency, must disclose their personal information to the Electoral Commission. Once submitted, this information becomes public and can be subpoenaed by other candidates. Atiku took this route, obtaining a subpoena from the court to access Tinubu's particulars, which included documents Tinubu submitted to the Electoral Commission. Among these documents, a discrepancy was discovered in Tinubu's certificate from Chicago State University. This certificate became a focal point due to potential implications under Nigerian law. The Nigerian law stipulates that a candidate presenting a forged certificate to the Electoral Commission can face disqualification. This observation prompted Atiku to include it in his petition before the Presidential Election Petition Tribunal, where he contested the validity of Tinubu's presidency declaration. Peter Obi, the Labour Party candidate, also challenged Tinubu's election and provided multiple grounds for his disqualification, including the forfeiture of $460,000 to the United States in 1993. This forfeiture followed investigations by U.S. law enforcement agencies, which linked the money to narcotics trafficking, resulting in court-ordered forfeiture. Now, returning to Atiku's involvement in the district court in Chicago, he sought a subpoena to acquire Tinubu's admission records from Chicago State University. In response to Atiku's claims in the Nigerian court that Tinubu was ineligible for the presidential election due to the certificate issue, Tinubu's legal team demanded evidence supporting the assertion. This led Atiku to Chicago, where he had previously presented a witness who showcased evidence obtained from the Electoral Commission and Chicago State University. Notably, upon receiving Tinubu's certificate from the university, a discrepancy was immediately recognized compared to the submitted document. The university's representative insisted that the certificate provided to Atiku was inaccurate and requested its destruction. Chicago State University's behavior raises suspicions. It was revealed that the university had already disclosed these records to David Hundian and Associates the previous year. Atiku's action in Chicago stemmed from the requirement to present evidence meticulously in Nigerian court procedures. Despite having a subpoena, Chicago State University instead opted to involve Tinubu in the litigation. This led to Tinubu retaining 5 lawyers and seeking to join the proceedings. Remarkably, one of his attorneys bears the name Oluwole, which colloquially signifies something fake or forged, adding an intriguing layer to the narrative. It's essential to clarify that the involvement of a U.S. court doesn't pertain to deciding West African or Nigerian matters. Rather, it's due to the university's involvement and Tinubu's resistance to releasing his school records. Following arguments by Tinubu's legal team that his privacy would be violated if these records were released to Atiku, the court granted Tinubu until August 24th to provide substantial reasoning and arguments against the release of his academic records. Returning to the response from Tinubu's legal team, they assert that Atiku's challenge pertains solely to the election results. According to them, the records sought from Chicago State University have no bearing on the ongoing election petition in court. However, considering the narrative thus far, the importance of these records becomes evident, particularly given Tinubu's history of certificate-related controversies and forgeries. During his time as Lagos State Governor, he initially claimed attendance at a non-existent secondary school in his electoral documents. When confronted, he attributed the error to an associate's filling out the form, never rectifying the incorrect school name. Remarkably, even in his documents for the presidential election, he left both primary and secondary school sections blank. In their bid to persuade the U.S. District Court judge to prevent the release of Tinubu's Chicago State University records, his legal counsel argued that Atiku's challenge solely concerned election results, and that the school records pertained to a separate matter. According to Tinubu's lawyers, Atiku's involvement should not extend to this litigation, asserting that there's an attempt to blur the lines and create confusion. It is anticipated that Atiku's legal team will provide clarification in their response and set the record straight. Although these records may no longer be relevant to the current presidential election petition, they could be utilized in subsequent legal proceedings, such as an appeal to the Supreme Court of Nigeria. This is in line with the country's Supreme Court rules, which permit parties to introduce evidence during appeals. Attempts to conceal the information Atiku is seeking could provoke curiosity, involving all parties, including Chicago State University staff, lawyers, and the judge. The specter of potential identity theft looms as it's evident that the individual admitted to Chicago State University in the 1970s was an American female, not the Nigerian figure known as Tinubu. The university had publicly disclosed this information in response to a previous subpoena last year, leaving little room for secrecy. All parties should bear in mind that assisting in hiding evidence could be perceived as obstructing justice. Tinubu's legal team's assertion that Atiku is not an interested party holds a degree of irony. Beyond elections, institutions have the right to verify the authenticity of documents submitted to them, especially if they suspect forgery. This is precisely what occurred when a lawyer visited Chicago State University under subpoena last year. He obtained documents and subsequently brought the case to court, a parallel to Atiku's actions. Atiku, as a presidential candidate alongside Tinubu, Peter Obi, and others, holds a legitimate stake in seeking disqualification of an allegedly fraudulent candidate. Moreover, Tinubu's alleged involvement in narcotics trafficking and money laundering adds further complexity to the situation. Reports from the EU on the election highlight flaws, indicating a failure to meet standards established decades earlier in 1993. Despite extensive technological deployment and considerable expenses, manipulation of results persisted through real-time result upload blockades. Contrary to Tinubu's legal team's claims, Atiku's involvement is integral to the litigation. Disqualification for certificate forgery is stipulated in Nigerian law. It is hoped that Atiku's legal representatives will present a compelling argument to the judge, emphasizing a key legal principle. If a party seeks to withhold evidence, it implies the evidence's detrimental impact on them. In such cases, a judge should act swiftly and grant a subpoena without delay. If you are watching our video for the first time, I suggest you subscribe to our channel for more interesting and captivating information. Turn on the bell notification to get alert on all our recent posts so you won't miss out any. Share your thought in the comment section and share these videos with family, friends, and concerned Nigerians. Thanks for watching.